Good afternoon. Thank you for joining us this afternoon. Housekeeping items. This is live. And so if you are watching this by recording, we're glad you found us and hope that this information is helpful. My name is Angela Lopez, and I'm an attorney, shareholder in Cowles Thompson.
My name is Michelle Alonzo. I'm an attorney and shareholder here with Cowles Thompson as well.
This afternoon, we're going to talk to you about labor certifications, recruitment, specifically under the light of the latest settlement with a big tech company. We're going to give you a little bit of background about the labor certification, and then we're going to go and discuss the settlement and what that means in terms of the recruitment for those who do employment-based green cards.
So many of you might be familiar, the way that you can get sponsorship for your green card for permanent resident in the United States through employment sponsorship is often referred to as PERM, or the PERM process. And this is a multi-step process that is handled, but there are two agencies involved. And the first one being the U.S. Department of Labor. And that's the big player that we're going to be discussing here because they were party to this settlement with Facebook. By way of background, a permanent labor certification is issued by the Department of Labor, and it allows an employer to hire a foreign worker to work permanently in the U.S. So you'll see that there's going to be a portion about this PERM process that is looking to see that the employer has tried and was unable to find a qualified, willing, and able and available U.S. worker for the position. So this PERM process is that overarching process of how we get to say, nope, there's no one here that's really available. So you should allow us to bring this foreign worker into the U.S. labor market. Now, this applies to full-time workers. We're not talking about university teachers or nurses or physical therapists. Those are a separate process. And the recruitment window that we're often looking at is small, but recruitment nevertheless has to be done within 180 days of the application. And again, this goes back to the test of the labor market. Now, we put in there, it's a labor test or it's a test of the market in relation to minimally qualified U.S. workers. Angela will explain a little bit later on in the presentation, but it's interesting that the terminology used in the settlement agreement just says qualified U.S. worker, but oftentimes if you talk to other practitioners or other human resources professionals that are familiar with PERM, I mean, we often talk about how we're discussing the minimum qualifications for the position. One of the major attestations that employers make in relation to the PERM process is that they're going to pay the prevailing wage or higher, right? Whatever it is they pay to U.S. workers, same wage to foreign workers that obtain this permanent residency through the PERM process. We'll go on to the next. So just housekeeping, right? If you're familiar with PERM, this may be a little bit redundant, but from the very beginning, when we look at a case and we're looking at PERM, we're looking at a very specifically identified and defined position. And all of that has to come from the U.S. employer. They tell us who their, what their qualifications are for this position. Job duties are outlined. And the interesting thing is we can't get too creative, right? The process is a little bit archaic because we run into more modern companies that want to talk about a whole multitude of qualifications for their potential employees or for the best fit in a position. But we have to look at it and very much gear folks back to what's customary and usual for the occupation, especially the one they're looking for. Very careful, you cannot tailor the qualifications to the foreign employers or to the foreign worker. You cannot say, well, the employee we want has XYZ credentials, a master's degree, for example, and 3.5 years experience and has these certifications. So that's what we need. It's got to be objective and it cannot be tailored. That's where we can, employers can get into trouble. And it can't be unduly restrictive. Now, we do put on there, business necessity can substantiate some of those unduly restrictive job requirements. Traditionally, one that we often run into is a foreign language requirement, especially with international companies. foreign language requirement is necessary for their business operations, but from the U.S. labor market perspective, it's unduly restrictive. But some companies can very legitimately justify why that foreign language requirement is there. And the second major component is the prevailing wage, right? Because that's one of the major attestations. So you'll see on the slide, it mentions OES wage surveys can help determine in advance sort of where you could expect that wage to come in. We often look at it for guides for some of our employers to kind of know where that wage will land. Sometimes it's not an issue, but definitely something that needs to be addressed.
Great.
So yep, go on.
Moving on, and as Michelle mentioned, this is just a little bit of background. So when we go into what the bulk of the conversation today is going to be, then it makes a little bit more, we can put things in perspective. Just a quick reminder here for those who are watching us, and thank you for being here. If you go on to, you can type your questions. If you go to the bottom of your screen, you might see a little section that says more. Click on there and you're going to see a little box that says chat. Please type your question. We'll be monitoring the chat box and we might be able to respond to your questions throughout the presentation. So moving on with recruitment. So what we are looking for, or what we're trying to do here with recruitment in terms of a labor certification, is to test the US labor market. Testing means employers want to see if there is US citizens or legal permanent residents or people who are here on legal statuses permanently, like asylees and refugees who have work authorization, if they are available, willing and ready to take the job when the advertisement recruitment is being run. The required recruitment, and here is where employers walk a very fine line in between what is standard for them, and we'll talk about that in a little bit, and what is required by the regulation. So for labor certification purposes, employers must place a job order with the state workforce agency. In Texas, that would be the Texas Workforce Commission. This job order must be up for 30 days. And then for the next following 30 days, employers have to wait and see if there are any responses. During this time, employers can complete the other additional recruitment that is required for the labor certification, which are what? For professional occupations. That means occupations that require at least a bachelor's degree in the United States, then employers are also required to place an ad into Sunday newspapers. I know.
Who uses the newspaper to find a job?
I know this is actually is a gift. that's part of the recruitment, and it must be advertised. Although not a lot of people are looking for job and then Sunday newspaper. Also for professionals, in addition to the job order and the 2 Sundays, the requirement is to do 3 additional methods of recruitment. And here is where people need to be careful to look into what is normal practices, and at the same time, take a look at what are the additional 3 options that they might have to do recruitment, because the Department of Labor provides a list of about 8 to 10 methods of recruitment that people can use, including journals, websites, employers' websites, or recruiters' websites, recruiters, campus advertisement, and some sort. But there is a very specific list, and the recruitment must be conducted within those parameters. There is a notice of filing that is not recruitment. That is a notice that has to be posted at the work location, meaning where the employee is going to be working, in a place that is easy to access by other employees.
So traditionally that was the breakout room, right? Or the break room.
Or yes, where employers most commonly place notices for employees, Department of Labor notices. So they are aware of what is going on.
But in light of COVID, where are we seeing that now? There's the intranet, right? They have the corporate.
Well, they're doing different practice. Still, they need to post it at a place where employees are going to see it. But if everybody is working from home, then they give a notice. If they don't have an intranet, like Michelle mentioned, then by email. massive for all employees, but this notice must be visible to employees. And then at the end of the recruitment, and before they can file the labor certification, which is done online, as Michelle explained, the employers do a recruitment report. And on this report, what we're going to see is who applied for the job, if anybody applied for the job, and what reasons for disqualification, or if there is somebody who might be qualified and can be, there are no reasons for not offering the job, well, then maybe that employer may have to stop the labor certification process. That doesn't mean that they have to hire the person immediately unless they are able to do it, great. But what that means is that they cannot proceed with the labor certification. So when employers are undergoing the recruitment, we always give them a log, with a spreadsheet that they can use to input or keep records of any applications they might receive, when they receive it, and whether or not they meet the minimum qualifications, so that they are contacted. And how they are contacted? Well, what normally is done when they are recruiting today, is very normal for employers to pick up the phone and call the applicant before they even set up a in-person interview. And sometimes the in-person interview never takes place, because once they go through the information on the application and the job requirements, sometimes those potential employees disclose information, so they might not be qualified for the job. So, but they are supposed to do what they normally do.
Right, and this leads into exactly what we're sort of talking about, right, in terms of record keeping.
Yes, and that goes into employers maintaining all the documentation after the recruitment is completed and after the labor certification is filed. Employers must have detailed information, specifically if they are rejecting or not rejecting, but not proceeding with a specific candidate because it doesn't meet the requirements. The recruitment report also include the number of employees and the minimum requirements for the position. Here is where we start getting into the little and the more specific requirements, because it's not just recruitment.
Right, it's not just the specific requirements. What we just kind of explained in very, very brief and an overview is the perm process. But as Angela and I have been going back and forth, good faith recruitment is there in the regulations, and it's this overarching requirement that encompasses all of these other very enumerated and very specific recruitment steps that employers can engage when they're going through the perm process for employees. And this is exactly at the center of what this litigation, well, it didn't result in litigation, but what the settlement actually resulted. And you'll see when, we'll discuss it here in a little bit with a little bit more detail. Department of Labor and Department of Justice said, hey, Facebook, good faith recruitment means good faith recruitment. You deviated from standard practices and other recruitment efforts than when you were doing recruitment for these perm highlighted or specified positions. So,
but in other words, what we're saying here is that the recruitment for labor certification should not be something completely different from what employers normally do, because then there is where the Department of Immigration start looking at whether or not the recruitment is in good faith. Good faith means they are really looking for someone to fill the position. And yes, we understand that most of these labor certifications are done for people who are already working with the employee on temporary visas, temporary work visas. Temporary means they're not here permanently. They can only stay here for as long as the visa is valid, which in the eye of the Department of Labor, that is not a permanent job for that individual. So that's why the employers can go out and look for somebody. And good faith goes is, are you really looking for somebody? What are your practices? So we very frequently, when we're working with employers and we're talking about recruitment, we talk about what do you normally do? Because we want to make sure it's consistent So if they need to do what they normally do in addition to, then we'll do it. So that's good faith. Couple of things on good faith, and we're very careful here. We know the Department of Labor looks at when the recruitment is done. So for example, if all the recruitment is done during the holidays, that might be very easy to justify, but not necessarily shows good faith, because many people during the holidays, they're out, they're not even in the city or even in the country, they might be on vacation. The spirit is different from looking for a job. So, or when the recruitment methods are kind of just looking to hide information rather than giving out information. So that's what good faith means.
Okay, so now we'll get to exactly probably why you're here. How has perm changed in the landscape of the settlement? So what happened is that December 3rd, 2020, the Department of Justice filed a lawsuit against Facebook. And this was a very alarming complaint that was filed, because it alleged that the company was engaging in unfair recruitment and discriminatory hiring practices based on citizenship or immigration status in violation of the law. And while this complaint was filed, there was an investigation that was explained. And what had happened is from January 1st, 2018 till at least September 18th, 2019, the Department of Justice very specifically in their complaint listed what they thought was discriminatory about Facebook's hiring practices, and how and basically identified what they were doing in terms of treating those perm track employees versus everyone else when they're recruiting for positions. What resulted is there was absolutely no litigation. There was a settlement, and that was October 19th of 2021. So just a couple months ago, that both the Department of Justice and the Department of Labor, so two separate agencies reached and entered separate settlement agreements with Facebook, because while the Department of Labor is focused on the perm process, the Department of Justice is looking at discriminatory practices.
So what are the most important terms of these settlements or agreements, whichever way you want to call it? So we see, first of all, the fact that they signed an agreement doesn't mean that Facebook is admitting to having any liability. In other words, Facebook denies the government's allegations of U.S. worker discrimination. So they're not agreeing to that, definitely not, but they are agreeing to settle the matter, so they're not going to be dragging this through court and disclosing other information that probably Facebook doesn't want to disclose. It also is only effective for 3 years from October 19, which is the day they signed the agreements. And that means that during these 3 years, Facebook must meet all the Department of Labor requirements. They're going to be watching very closely that the Facebook meets all the specifics in terms of how they are going to fix the things they've been doing wrongly according to the Department of Labor or the Department of Justice. In these terms, they monetary stipulations, meaning they have been fined or they have to pay, and according to sources, this is probably one of the biggest settlement for the Department of Labor in terms of the labor certification program, not for Facebook. For Facebook, this is pennies, but for the Department of Labor is significant. And so the civil penalties include, I'm trying to look at here, include $4.75 million to the U.S. government that they have to pay.
Right, it's the civil penalty to the Department of Justice. And because it was discriminatory practices, they also created that settlement fund to the tune of a little over $9 million for U.S. workers who meet that definition of qualified individuals.
Yes.
And so what does that mean, Angela? They're making changes to perm recruitment. That was very clear.
Well, they also have to meet some requirements in terms of how they will be conducting recruitment going forward, at least for the next 3 years. But I'm pretty sure that is going to be implemented to stay, because now Facebook is in the radar. So what are the specific changes to the perm? They have to accept electronic resumes or applications on their website, same as for any other positions. And that goes to what Michelle was explaining before, that they were not complying with certain practices. What they were doing normally for some employees, they were not doing for those employees that they were sponsoring for labor certification.
Right, that was specified in the allegations. They would accept electronic resumes for, the non-perm track, open positions. But if they were looking at the perm track position, they weren't accepting. They were actually requiring them to file by mail, which I don't, just like the Sunday ads, I don't know how long, I don't recall in any recent history seeing people apply for a position by mail if it wasn't through perm.
Correct. So they're also required to encourage applicants to apply for the position, like Michelle says, but in any way possible, electronically, but not necessarily just by mail. IT workers, honestly, they don't use the mail very frequently. Post the perm-related positions on company's website in the same manner as they do every other position for the company, and enter all applicants for the perm-related position in company's internal recruiting system for consideration for related job opportunities, which they were not doing. In other words, if somebody applied for the specific job for the perm, that's it. That was the only thing they were considered for. Although this one, I kind of disagree, because the regulations do not specify that if somebody applies for the job, but if you have 3 other different jobs, you're supposed to consider that person for all the jobs that you might have available. It's the labor certification and the regulations are very specific. If you're advertising for a specific job and the person doesn't meet the minimal qualifications, well, then it doesn't qualify. But here, under the agreement, they're supposed to also consider these people for other related job opportunities, which to me is a little bit beyond the regulations. Change to the perm recruitment practices, they also have to take other steps to ensure that recruitment for perm positions closely resembles the company standard recruitment practice. And here is where we go with good faith practices.
Yes, and I think this is a little bit of a deviation of what a lot of employers that engage the perm process are going to have to adjust. This is what we're dealing with in a post Facebook settlement, perm world. This is exactly how it's going to be. What are your standard recruitment practices, and lining those up? And I know, Angela, for the longest time, that's how we've been advising our employers. But that's not necessarily what's been the norm across the board. And so I think we're having to line those up now. And this settlement makes it very clear that that's probably best practice. That is best practice.
So what we were saying at the beginning, and for all of those on these presentation that do labor certifications, you walk a very fine line between meeting the requirements and doing what is normal or standard in terms of recruitment. And what we normally do when we are working with a client is we sit down with them. And the first thing we want to know is, how do you normally do recruitment, as we mentioned before? But also, we pull up our checklist, and then we try to incorporate the recruitment that is required by the labor certification into their normal standard recruitment, so that they are meeting all the requirements, DOL recruitment requirements, as well as good faith and complying with what they normally do. This specifically is, you can see the difference specifically when they are reviewing resumes.
Yeah.
Because many times when they're doing recruitments, they just wait to the end of the recruitment. So if the recruitment takes 2 to 3 months, at the end of the 2 or 3 months, some employers come back and they say, hey, so we received so many resumes, what do we do? And here we're looking at, when did you get them? Well, some came at the beginning, others in the middle of the, and some of them you can see they have been just sitting there for 2 months. That really is not what they would normally do, because if you're looking for somebody, you would review that resume or CV immediately.
They get a strong talking to from the attorneys about
Yes.
not following the
Yeah, so they would normally review the resume or the application. And if the person seems to qualify, they would follow up. They wouldn't wait 2 months to follow up because that's kind of against the normal standard practice for recruitment.
That's definitely not good faith.
No.
And I think that's one of the biggest points that we want to stress through this Facebook settlement is that good faith recruitment is got to be the umbrella under which all recruitment is conducted. And we're stressing that to our employers, that's for sure. So employers, what are your takeaways? You got to take all necessary steps for recruitment for perm positions. Again, I mean, we cannot stress this enough. Good faith recruitment is throughout the process, but we've been discussing about how this is challenging because again, you know, you saw earlier the Sunday ads, radio ads are still one of the enumerated ways that you could do perm recruitment. I don't know anybody who still listens to terrestrial radio a lot. So, you know, that's challenging, but you could check off, an employer technically could check off that box and meeting with the standard for perm regulations for perm recruitment, but they're obsolete. And so, and if that's not how the company is genuinely getting employees or attracting you know, talent, then can you really engage that and still be operating under good faith? So you have a way to meet the regulations, but is it going to be deemed not in good faith when they look at it, you know, take a step back and look at it and say, well, yeah, you checked all the boxes, but when's the last time you did a radio ad? You only did radio ad for this particular perm, and, you know, for this particular employee. It looks like you're trying to limit the number of applicants coming in, you know, is that good faith or not? So that's what's unsettling. The other thing that we were talking about, and I think we were going back and forth a lot about, is minimally qualified applicants. I know the Facebook settlement mentions qualified workers. We talk about minimum qualifications. And during traditional recruitment, you know, the HR that we work with, they talk about, we want the most qualified, right? We want someone who just comes in as a rock star, is going to meet all, but perm kind of turns it on its head. Perm says, you know, if you have these 3 requirements that are enumerated and listed by the employer, then you got to consider them. And it could basically, you know, end your perm because you can't offer, you don't want to offer the job to that person, but you can't continue because you found a minimally qualified applicant. So,
but here we also have to look into, and for these settlements or agreements, we need to keep in mind that the Department of Labor settlement is confidential. So we don't have a lot of information, is private, nobody's going to see it. The Department of Justice is more a public record. So whatever allegations about discrimination, because they have different practices for US citizens, permanent residents that they do for foreign workers, then that is more a public record than DOL. So, but when they talk about minimum qualified employees, is according to the definition they enter into on the agreement. So yes, for labor certifications, we start with minimally qualified, which means if your requirements are a bachelor's degree, 3 years experience, a license and a specific or a foreign language. So those are your 4 requirements. And if the person who applied for the job on the face of the resume meets those 4 requirements, and there is no way for you to tell whether this person is a US citizen or, because no one says, this is a resume, I am a US citizen. No, people start with the normal contact information, education experience, and they go from there. No one lists their US status. However, many people who are here on temporary visas, they do list their statuses under their, and they do specify H-1B or looking for sponsorship, and immediately you know, well, that person is not even a US citizen. You don't even have to consider the resume because you're looking for a person who can permanently fill the, and you won't be discriminating against a person who says, I'm in an H-1B. Because that's the purpose of the recruitment, finding a US citizen or legal permanent resident.
Exactly. So let's see. companies are encouraged, obviously, as a result of this, to seek counsel.
Yeah.
We're here to advise and to help you go over your perm program in light of these new developments, because probably the biggest takeaway I think that we were also discussing earlier is, enforcement. Seeing the DOJ come in, enforcement traditionally has been by the DOL. DOL will go in and audit. You can always be subject to an audit for the perm process. They have auditing procedures. They have supervised recruitment. They have these mechanisms.
They are the overseeing entity.
But DOJ coming in is just another agency that, has authority to come in and investigate. It's just an enforcement practice that we haven't really seen. So this is unsettling.
And a couple of things that we always hear through the years and many of the seminars and conferences that we have attended is many times these agencies are clear about we get involved when we do investigations many times, and mainly because somebody, maybe a disgruntled employee, complains about the company's specific practices. There goes the discrimination allegations. So it could have been that somebody complained to the Department of Justice for discriminating practices, and from there they started the investigation. Or it couldn't be that the Department of Labor had doubts. You never know how the investigation starts. All you need to know, honestly, is the law and regulations related to the labor certification recruitment has not changed. We still need to do recruitment as we have been doing it. What has changed now is that we know that there is more than one agency keeping an eye on how employers are conducting this recruitment, because again, there's a fine line between doing good faith recruitment and or discriminating against U.S. Workers. We said, if you have an attorney, if you're working with an attorney, if you're doing your recruitment, well, I think this is a good time to take a look at how you're doing it, to make sure that you do what is normal, standard in your company, and at the same time, you meet the Department of Labor requirements, because that's what you're going to be judged on, good faith. That is what good faith recruitment means. We're going to open now the line for questions. I see here a question in our chat, and the question is, so if I am doing the recruitment and I receive a resume from somebody who on the resume, let me see if I'm reading this correct, states and shows that his education is from a different country, can I assume the person is not a U.S. citizen?
No, not at all. No, we have naturalized citizens that have foreign credentials that would be a U.S. qualified worker because they're a citizen. So foreign credentials are not indicative or dispositive of not qualifying. As a matter of fact, we work with foreign professionals all the time, and we do get U.S. equivalency certifications regarding what their degree is according to U.S. standards. And so absolutely.
So if there is no other indication on the resume that the person is not a U.S. citizen or legal permanent resident, this is one of those cases where you want to pick up the phone and make a little call and see. And a question, and this would not be discrimination or discriminatory practice, if you ask the person if they need a sponsorship. You're not asking if they are U.S. citizens, because that's not supposed to be asked. You're not asking if they are if they have work authorization. All you're asking is, do you need a sponsorship? And people who need a sponsor or employment sponsor, if they do, they'll tell you, yes, I do. Then you know.
They'll know that question. A U.S. citizen will probably say, what?
Yes.
What do you mean?
Yes, a U.S.
I want a job.
What do you mean a sponsorship? I need a job. Yeah. People who are not familiar will say, yeah, I need somebody who sponsored me a visa. There you go. There's another question here that talks about, is asking how long the recruitment must be, for how long people have to keep advertisement or do the recruitment.
I can take this one. So recruitment window depends on when you start and when you stop. Oftentimes, most recruitment we try to keep or advise within 30 to 45 days. There's a way to sort of meet all your requirements and meet all the needs within a shorter window. However, as long as recruitment's done within 180 days, you can go as long as 6 months. And that's really kind of where, if you look at, I was looking at some of the allegations on the complaint, Facebook kept their window pretty tight as well. And as most of us, we try to, because
Yeah, we normally, for us, when we do a labor certification, what takes the longest to obtain is the prevailing wage determination that we mentioned at the beginning. Why? Because the agency is taking, we're seeing 8 to 9 months to issue a prevailing wage determination. And you really, you could start recruitment before the prevailing wage determination. The problem is that if the determination takes longer than the 180 days that Michelle mentioned, then the recruitment expires and employers have to do more recruitment. So you want to be careful when you start, because definitely you cannot file that labor certification without that determination. So, but once determination is obtained, in our practice, we try to complete the recruitment within 60 to 90 days and file that labor certification after the 60 days, definitely. But within a comfortable 90 to 120 days, that's 3 to 4 months, is totally doable. So we try to stick to that term because I think it's fair and it can be done. I worry about those recruitments that are taking more than 5 months. You start getting into deadlines and you don't want to be there, but the recruitment doesn't take a year. And when you're doing recruitment for labor certification, following standard procedure and complying with the Department of Labor requirements, you can conduct and complete the recruitment within 60 to 90 days.
Right.
That's reasonable.
And most of the HRs that we work with, they want to have this, over and done with fairly, quickly and efficiently as well. So that it sort of meets the employer's objectives. We sort of keep with our timelines, and everyone wins so long as everything goes well and we don't have.
Yes. So somebody asked here about how subjective good faith recruitment can be.
Oh,
well, it is in the regulations, and I don't think it's subjective at all. I think the Department of Labor, they release information very frequently, and they have these Q&A when it comes to labor certifications. And through the years, they have been very clear about what would be those triggers for them to question good faith recruitment. Actually, they're very clear about how the recruitment is done, normal practices. So if you do something for people applying under a perm labor certification that you would not normally do for US citizens, that definitely is not good faith. If you are doing recruitment, like I said, during the holidays and using certain methods that are not very visible, they might question the good faith. We also have cases where family members are sponsoring family members, and they do question the good faith recruitment. Why? Because, for example, and we had the cases.
Like we've structured a way, and there is a way to go to do it.
And we had cases where sister siblings have sponsored siblings. I have a case where one of my employers sponsored his brother-in-law. And the first question is, well, how is this going to be good faith when you would not hire somebody who you do not know instead of giving the job to your brother-in-law, to your sister, or to that person that is a relative? And that they question it. So we have looked for ways, and some of our employers have what they've done to make sure recruitment is done fairly, and they don't have a say or interfere with recruitment, so we can demonstrate good faith throughout the entire process. They have gone out and hired a third person or a company to handle the recruitment. Not just for that specific employee, because then that would be doing something that is not a standard, but then for a certain period of time, they let the company handle recruitment for the third party company to handle the recruitment for their company, including the labor certification they're undergoing. And that way they can honestly tell the Department of Labor, we were not involved. They handled the recruitment, they reviewed the resumes, they were the ones who decided who qualified, who didn't, and why those that didn't make it didn't qualify. And then we have been able to get labor certifications approved that way.
Exactly. Those have been a little bit easier nowadays because most folks or a lot of companies, especially small to medium, will outsource that HR component.
Mm-hmm.
They don't have the time to be reviewing resumes. They'll tell this third party vendor, exactly what they're looking for and who to pass through to them. So if that's already, a standard practice or a cost saving practice for the company, it makes sense. And it helps in these situations where you actually have a qualified person that you want to sponsor for perm that just happens to be a relative, but you want to conduct this again in good faith.
In good faith. I have one more question, and I think we're going to close with this one. Unless there's one more, we might entertain two more. And the other question, so labor certifications are only for professional people or people who have bachelor's degrees?
No. Labor certification is also available for skilled workers. Now,
What are skilled workers?
those are no bachelor's degree, basically. But that one is posing to be a little bit of a challenge. However, we are seeing some success in those right now because employers across the board are having trouble, getting any employees in anyway. So the labor market, though the Department of Labor is saying, is flooded with a lot of potential employees. Companies are struggling to hire people. So,
and the good thing, well, not good thing,
but skilled workers.
Yes, skilled workers, there's a difference in terms of the recruitment. Because for professionals, they do require, as we mentioned before, the job order, the Sunday news, and 3 additional methods of recruitment. For skilled workers, the 3 additional methods of recruitment are not required. Yep. So it's a shorter recruitment, although there is recruitment, it still has to be done in good faith. The same rules apply, but yes, you can do labor certifications for individuals who do not have a bachelor's degree or higher education.
Right. And the reason why we normally discuss those with bachelor's degrees, because it's the movement between H-1B to perm. It's a common jump for a lot of foreign workers and foreign professionals are here, but we have so many that are under other statuses that would qualify as skilled workers, and we could definitely do the perm process for them as well.
One more question, and this is the last one, so because we want to be considerate of your time, and it is about the recruitment for what happens then if you find someone who is qualified for the job. Can I ever get a green card through a labor certification? Is the question.
Yes, you could, but the perm process is suspended. You have found a minimally qualified applicant. You basically have to scratch that recruitment and wait some time.
And the reason you have to stop it, or the employer has to stop the recruitment, is because when the employers are going to file that labor certificate, or when we are going to file the labor certification online, one of the things that we are attesting, and the employers are attesting to when they are signing those documents, is that they were not able to find anybody who was qualified for the job. And since there is somebody who might be qualified or is qualified, then they are not able to attest to that, so they won't be able, and then suspend the labor certification. That doesn't mean, like Michelle said, suspend it for a while. Yep. Maybe you want to try it in a year or two, or go to somebody else, another employer who might be able to do the same process. But that specific labor certification process has to stop.
So if you're on the employee side, I guess we'll just add, and you have limits on authorized time here. That's where it becomes critical. If you are going to your employer and they're willing to sponsor you in a perm, you don't want to put this off, especially with, as Angela mentioned, the DOL's processing times for that prevailing wage. I mean, you're going to be losing well over half a year and just waiting on that determination, which is a critical component. So yeah, you don't want to put this off.
So, okay, I keep saying last question, but this is seriously the last one because this is a good one. The question is, so can you attorneys help us out with the recruitment and look at the applications to help us out to decide?
No.
No.
No, we can advise in terms of the requirements and give advise them to sort of how to stay within the regulatory requirements of that, but recruitment, qualifying them, disqualifying them, those are all business decisions that are strictly under the purview of the employer.
What we normally do when we're doing labor certifications is early in the process, before we start anything, we do sit down with the employer to explain to them, because this is kind of a foreign for employers. A lot of the labor certification rules and regulations don't make a lot of sense for business people, because they would not do certain things within the standard practices, and then they have to accommodate these things to meet the Department of Labor requirements. So we do sit down and explain not only the recruitment, but what they need to do, and we give them the lock, like we mentioned, so they can keep, and we tell them, as you receive resumes, we're not going to be reviewing them. You do the reviewing, you complete the data, you go through the motion, and objectively, you need to decide whether or not that person meets the requirement. We do review that recruitment report and the CVs at the end of the process to make sure that whatever they have there makes sense. Because if we have questions about any of the applicants that they disqualified, believe me, the Department of Labor is going to have the same questions or worse.
Exactly.
So that's when it comes to that part of the process, we can't really get involved or help at all. We look it up at the end. So no, we can't help with recruitment review. All right. So I don't see any more questions. We thank you very, very much for joining us. As I said, this is live, and if you're listening to this by recording, we appreciate your time. Contact us, feel free, and we'll see you next time.
Right, and be sure to subscribe.
Yes, thank you.
Bye-bye.